come accidentally out of anybody's charity. It has come out of the declaration in the Constitution, where we have constituted ourselves into a democratic republic. We have not converted ourselves into an autocratic republic. A democratic republic defined in the Constitution, when wants to enact regulatory bodies which will be absolutely devoid of and devouring of the democratic principles, whether they will be standing onto the real test and truth even on that context is something which will be required to be tested. Universities, which are a major stakeholders. Government of India does not impart education. Education, in spite of being in the concurrent list, it is imparted through educational institutions which are required to be affiliated to the university, because degrees cannot be granted by anybody other than an institution which is a university under section 2F and 3 of the University Grants Commission Act. Universities have no representation. And where the representation, if the university comes, the state may think of nominating the vice chancellor of the health universities. Number one, all states do not have health universities in this country, and therefore even the limited choice of the vice chancellor of a university of health sciences finding a place in the composition of the council is not mandatory. It is discretionary. A, he may be, he may not be, and B, universities which do not have a health sciences university, they will be barred from the very eligibility as regards the nomination on this count is concerned. State medical councils which regulate medical practitioners within the respective states have no representation. We have been always talking of federal polity. Federal polity has been taken to be 1985 Justice Sikri's judgment, what is uncompromisable in the Constitution. 5 tests have been declared which are uncompromisable in the Constitution, designating it to be the basic structure of the Constitution, and in which federal polity has been said to be an uncompromisable structure or facet of the Indian system of democracy. Federal polity in the context of medical education meant state medical councils and Medical Council of India having a national character. And it is precisely for this reason every state council, that is registered medical graduates election was representation to the RMG of that particular state, meaning it was a representation to that particular state medical council, invariably almost in a statutory character. That has been taken away with when we are talking of the composition of the Medical Advisory Council. Chairperson of the NMC is an ex officio chairperson of the MAC. Now this strikes at the root of, you are wanting autonomy to be vested. Then what is the purpose of putting across these ex officio positions? If I am required to be dispensing my role, if I am in an advisory role, I cannot be in the executive role. And if I am in the executive role, I should not be in the advisory role. And if I am in both the roles, then the first thing which is compromised is the autonomy of the advisory body, which is so vital and which is so important, that has been given a go by. Under 3.2a, the word used in the text is faculty of medical institution, without indicating its nature as to whether it will be full-time, part-time, honorary, visiting, adjunct, what exactly it is. Absolutely. I mean, things have been put in a manner in so generic a sense that when you will be required to be looking into what exactly it will mean n number of things other than what it ought to mean. The expression used is faculty of a medical institution with the state is restrictive in as much as it will amount to teaching faculty only in a government-run college alone. The word of the usage of the word is such that if you really put it into the operation, it will mean in a restrictive sense. If you want to provide a restriction, be explicit, be loud, that we are wanting only this set of people to come and therefore the other set is barred. Why you are wanting to be playing hide and seek by coining the words in such a manner which will be indicative of inclusion, but more so it will also be indicative of exclusion. This cannot be said to be the specific nature of formulation of a legislation. As a matter of fact, the word which should be within. If the word with is broadened to mean within, then all the ambiguities which it is going to create, they are taken care of. Next slide. Medical Advisory Council under section 4(1). Role of National Advisory Council is entirely advisory. Thus it will have no powers to enforce its decision or any policy matter which it deems fit. It will turn into a toothless tiger. I mean, this is exactly, advices can be anything, but what is the import of that advice? At least the thing should have been, advices which are not executable should have been referred back to the advisory council. Advices which could have been, which the execution is wanting to alter, that should be brought to the notice of the advisory council. Advisory council has been made absolutely cosmetic in the sense, you render your advice once a year, forget for yourself, go back to your place, not to interfere. Advisory councils, in case of the regulatory connotation in the model where you are importing from, please go and see what are the powers vested with the advisory council. I will quote a simple example. Dr. Ajay Kumar is here, he is well aware of it. Postgraduate Medical Education Committee, when constituted, the protection which was given the statutory in character was postgraduate PG committee's recommendations can be approved by the general body, but cannot be rejected by the general body. They may be referred back with observations. In spite of that, if the difference persists, the matter is referred to the Government of India as an appellate authority, but the autonomy is not compromised, because postgraduate committee is advisory in character. And even those bodies which are advisory in character, how they are required to be insulated, not just remaining advisory on, please read section 20 of the IMC Act, and then you will realize what was the import of section 20 then, and what exactly has been made of the National Advisory Council. You will realize how exactly the mockery has been done on the set count. One of the functions of MAC is to advise NMC on measures to determine, maintain, coordinate minimum standards in medical education, training and research. However, surprisingly, not a single member is from medical education or from the university. You want me to advise on areas, you have given me a full umbrella without telling me where is exactly the arm of that umbrella on which it is required to be. How exactly the advices are to be given an arena in which there are no experts included into that particular facet. Where exactly that advice will come from? Who will be rendering that advice? See, you cannot be basking into the glory of your neighbor for the purposes of saying that it is his advice that you are wanting to be putting across. So there is a contradiction which I am wanting to be bringing to fore. The areas where the Medical Advisory Council would advise has not included the area of practicing of the profession. You talk of every advice. The real part is Code of Medical Ethics as a regulatory mechanism which evolves out of that area which is required to be covered, because regulations will be arising only where the parent clause is indicating that jurisdiction and function. In case it is not, subordinate legislation cannot be created. Now, if advising the practicing of the profession is not included, which goes to indicate that entire arena of Code of Medical Ethics is outside the zone of Advisory Council, and if that is taken away, then it is only the body which remains and the soul stands taken out. Coming to the Constitution, it has been brought out that the central government shall, by a notification, establish autonomous boards, and then goes to add that they shall be under the overall supervision of National Medical Commission. Now, if the boards are, I fail to understand. I therefore gave the example of PG committee. PG committee is a creation of general body of the council. 3 members of the general body are elected to the PG committee. 6 members are nominated by the Government of India from amongst the members of the council, not anybody. Restrictive qualification. They should have PG qualification with them and should have been teacher and or examiner for PG examinations in the university for a prescribed period of experience. And even with that being advisory, the appellate jurisdiction is not prescribed to the general body. Now here what I am wanting to put across is, you say that the boards are autonomous. What happens to the autonomy of the boards if they are expected to be under the overall supervision of the National Medical Commission? Is it not a contradiction that we are wanting to be creating? In other words, all autonomous boards, they are subordinate and they are subservient to National Medical Education, NMC, and this NMC is expected to be working under an umbrella of an advisory council which has, the advice of which is not binding in any way to this National Medical Commission. And therefore what I am wanting to put is, I am having somebody on me whom I am not supposed to be recognizing. I have somebody autonomous under me whose autonomy is totally under my control. And this is exactly the game which is there in the composition of this so-called three-tier mechanism which I am wanting to put before you. Which is an antithesis with reference to boards being autonomous in character and yet being subjugated to the overall supervisory control. Next. Under 6.4, chairperson and member secretary are appointed and nominated by the central government. Out of remaining 8 are ex officio members and 10 are part-time members. Out of 8 ex officio members, 4 are presidents of the respective boards and 4 are nominated members. Out of the 10 part-time members, 5 will be appointed by the central government from diverse background which are non-medical. Remaining 5 part-time members shall be nominated from amongst the members of NAC who have been nominated by the states. Now, I am putting across, this is all government ex officio. Now see the clever ploy. There are 30 states in India. This will lead to the following anomaly. As members of only 5 states can be nominated simultaneously. What will be the chance of every state being represented? Each state will be getting its nomination after 12 years. Today you are nominated for a period of 2 years. Now if Maharashtra has been nominated today, now Maharashtra after its 2-year tenure will have to wait for 12 years for its nomination back. And this is exactly where that nomination is worked out in a manner that even if the continuity is there, the operational period results in absolutely a vacant period almost which is more than a decade. And that too for a 2-year term against one nominee for fully a term in present MCI. Even in this, actually states will have no say as these members will be nominated by central government from among the members of the MAC. Now at least today when we are talking of the nominee of the state government, central government only notifies the nominee of the state government. They have no choice. My state sends name X. Government of India does not say, you send us a panel of 3 names and we will pick one. The name sent, the autonomy of the state is maintained. Here the autonomy of the state is not maintained. You may send the name. The government of India need not notify the same because they will be picking it up out of the MAC and therefore even the autonomy of the state has been jeopardized when it comes to choosing the nominee of the state for that particular purpose. This will mean what? Friends, this is exactly what I am wanting to bring to the focus. This will mean 100% nominated commission having no representative character which is contrary to the democratic tenet. The entire purport which I am wanting to bring into focus is this, and therefore the entire mathematics which operates onto this particular count has been depicted at serial number 1, and hence my conclusion at serial number 2 which I am putting across is it will be a 100% nominated body, no representative character, no democratically elected person, and whether it is in consonance with the democratic tenet or otherwise, I leave it to you for your speculation. Further, the situation is complicated by out of the 4 nominated members, 3 are from the representatives of the ministries who are non-medical in character. 5 part-time members are from diverse medical background. Thus, out of 18 members, 8 amounting to 44% will be from non-medical background who will decide policy matters that is expected to be regulating all of us. Whether it is good, whether it is bad, whether it is questionable, whether it is admirable, whether it is adorable, I leave it to you for your understanding and decision thereon. Next slide. The chairperson and member secretary are appointed / nominated. Now please see, here even the word nomination is not true. Ultimately they are appointed. And who are appointed? The appointments are public representatives appointed in this country or public servants are appointed in this country. When a person is elected, he comes into the category of deemed public servant for a public cause. But when a person is appointed, he is a public servant and therefore he is governed by the entire disciplinary jurisdiction of the appointee, and therefore this is a council which is going to be created out of employer-employee relationship. And whether this particular thing is acceptable for a regulatory body is something which is unheard of, and that is also an arena which I am wanting to be putting before you for discussion. Out of the remaining 8 are ex officio members and 10 are part-time. 4 are nominated. Out of the 10 part-time members, 5 will be appointed by the central government from diverse fields. 5 part-time members shall be nominated from amongst members of NAC who have been nominated by the states in rotation. This will also lead to the following. Now, second parable. What? General superintendence and control is with the chairperson. Chairperson is be all and end all. He is the final say, and he is an appointed person. So that, I mean, again I am telling you, the autonomous person, the autonomy of the structure. Although universities are no representation to universities, similarly state medical councils have gone unrepresented. Leave us, now come to the secretariat. What is provided for the secretariat is that commission would be headed by the member secretary of an appropriate rank. Now what do you mean by appropriate rank? What will be the rank of that secretary? Whether he will be of what rank? How can you not indicate secretary has to be always holding the rank because he is a member secretary? But here they do not talk of a rank. They only talk he or she will be of an appropriate rank without anywhere explicitly indicating what exactly that appropriate rank would be. Have you, see, ultimately when you talk of an appointment, can appointments be made by indicating that it will be an appropriate rank? It has to be a specific rank. Whether it will be of the rank of a deputy secretary, whether it will be the rank of the secretary in the governmental parlance, or it will be in the rank of principal secretary, what it will be, not indicated. Member secretary shall be appointed by whom? By the central government, and not by the National Medical Commission. His term of appointment is for only 4 years. All others in the National Medical Commission will have 2 terms. And with age bar, 65 for the members, 65 and 70 years. But secretary is for only 1 term. Is it accidental? Why are you wanting to have a secretary only? When he is an appointed secretary, why only 1 term? 1 term, that of 4 years. This condition, which is something unheard of, is expected. Will you be in a position to attract the real talent that you contemplate by putting an embargo of this particular nature? And therefore, why this particular thing has been put across is something which needs to be analyzed. Next. Appointment of chairperson and president. Selection criteria which has been stipulated, friends, is at least 10 years in leadership role in any area of the healthcare delivery, growth and development of modern medicine and medical education. Now, what does it mean? If you really ask me, leadership role, if this qualification fits anybody to the medical community in this country, IMA is the most significant custodian of the leadership role. This is exactly, now if you say that the leadership role is to be worked out, say, in the arena of healthcare. What exactly is the leadership role in the arena of healthcare? And these are all eligibility qualifications, ladies and gentlemen. Please do not be mistaken that I am describing to you an essay. That leadership role has to be in case I have to pick anybody, in the name of that leadership role, I will be in a position to play, because all other things remaining the same, this is a criteria which will be available to me in my hand, and I will be using it as I intend to, because the nature which I have put is the role not being defined, and the arenas which are put across is there also status, incorporation, dispensation, experience not indicated. Why? I leave it to your speculation. Selection criteria, at least 7 years in leadership role. What do you mean? If you take Vice Chancellor in the educational role, the maximum period which is available to a Vice Chancellor is the period of 5 years. And he is not eligible for reappointment in that university. That is a restriction across the country. Previously it was 3 years, 2 terms. Now it is 5 years, 1 term. Where do I get that 7 years? Even if you are a Vice Chancellor for 5 years, you will be deficient by 2 years of the leadership role, and therefore a vice chancellor has to clamor for a second term so as to be fulfilling this requirement of 7 years. Where exactly this 7 years has been brought in? What is the purpose of that 7 years? I am not debating that. But the whole purpose is, it is figurative in character and therefore it is misleading in nature. Search and Selection Committee. Now who is to select all these people? Search cum Selection Committee would recommend a panel of names for every vacancy, refer to it without indicating the minimum number of names to be included in the said panel. See, whenever a panel is recommended, a panel cannot be of 2 people. The minimum number of names to be put into a panel are 3. Supreme Court has stated that in case you are wanting to be making an appointment for a single solitary position, and if the number of applicants are not less than 3, you will not be able to conduct that interview, except in cases of reservation where protection is given, where eligibility is considered as suitability, and therefore for the purposes of suitability, the minimum number of names have to be put into the panel. And further, in case the autonomy is to be restored, the panels are not given by the selection committee on the basis of their observed merit, but usually autonomy is maintained by giving the panel in alphabetical order, so that it is left to the concerned person. You give the panel and let the person pick out of the panel. Hence the panel should be in alphabetical order and not in the order of merit. Therefore the minimum number of names in the panel to be indicated in alphabetical order restores the semblance of autonomy in the area of operation. The Search and Selection Committee is comprising of whom? The Search cum Selection Committee is comprising of totally government officials and government nominates. It is not made clear how the Search and Selection Committee would select personnel, whose names would be included in the panel of names. It is merely that Search cum Selection Committee may regulate its own procedure. Search cum Selection Committee is accountable to whom? If I am to decide my own procedure, UPSC is not entitled to decide its own procedure for selection. MPSC is not, any public service commission is not in a position to decide its own procedure. Here is a committee of super lords who will be deciding their own procedure, who will be giving any number of names in the panel, or if the panel name is not indicated, even if they recommend one name, who is going to object? And therefore that eligibility cum suitability will become binding. And it is in this count how exactly the entire tenets, they are being strange-holded for the purposes of ensuring that only the desired people who are already fixed are required to be put into place. Absolutely no window anywhere. The Search cum Selection Committee is authorized to regulate its own procedure, which is too liberal a connotation to be used in a statutory sense. You show me a piece of legislation. I have tried to work this out. Google search, I looked into n number of legislations on selection procedure. Friends, I have not come across any place where a selection committee, in terms of a statute, which is parliamentary enactment, is being said that you will regulate your own procedure. Because who is the author of this bill? Now the selection committee connotes that the said author will be an ex officio member of the selection committee. When I author the bill for myself, then I also ensure all these protections, all these insulations, they are invariably available. So this is person-centric. Had it been personnel-centric, I would have considered. But when the things are person-centric, they become difficult to digest, and this is the outcome of it. Next slide. Now let us come to terms. Maximum 2 terms for chairperson / president are prescribed. I still believe. Prescription of terms, think over, which is again the democratic tenets. Maximum age prescribed for chairperson is 70 years. And for the member of board is 65 years. What rationale? Now 70 years, 65 years, they are all. Are you saying that these are the ages of superannuation? These are the ages of eligibility, or these are the ages of... There has to be a justification which has been given. Whenever a restriction is put, ladies and gentlemen, it has to be a reasoned out restriction. A restriction cannot be unreasonable. A restriction cannot be uncharitable. It will be an autocratic restriction. You will have to justify why 65 in case of a member, why 70 in case of a chairman. Have you made that the chairman has to be a member first and then the chairman? then it is understandable that I become a member by the age of 65 and then I am eligible for the chairmanship, which is open and available to me for the age of 70. But if membership is not necessary for the purposes of chairmanship, this demarcation of 65 age for the membership and then 70 for the purposes of chairmanship is something which is absolutely arbitrary and without any application of mine. The age at which the chairperson would cease to hold office is stated to be 70 years as against for the president of the board member commissioners, which is contradictory, especially when the membership or presidentship of the board is not a condition precedent for the appointment of the chairman of the commission. Section 12(3) prohibits chairperson, president, member for accepting any employment in private college for a period of 1 year. Section 12(5) allows, now please see the contradiction, conflict of interest. It has to be absolute. Now how the conflict of interest is being negotiated? Section 12(3) prohibits the incumbents from taking any employment with the private medical college. Please see now how that is annihilated. Under section 12(5), central government can permit the said chairperson or president or member for accepting such appointment. Now why did you put the restriction? If it goes to indicate that if I am permitted by the government of India, the conflict of interest ceases. But if I am not permitted by government of India, then I am bogged down by the conflict of interest. Can conflict of interest be left? Conflict of interest is not a legal entity. Conflict of interest is a moral entity. It is more of a moral, more of a norm and less of a law. In this context, if government says, but आप imagine करिए what I am wanting to put across. How is it that the appointment by the government, permission by the government, will waive the conflict of interest? It continues to be. The conflict of interest is I will not consider the matter with which I am connected. This is the conflict of interest. Now here if you are permitted by the government, आप गंगोत्री के अंदर में नहा ले, गंगा गवर्नमेंट नाम की गंगोत्री आपको सर्टिफाई कर देगी, that particular conflict of interest ceases to operate. Hence, what is put across under section 12(3) is taken away by section 12(5). Can this be said to be a healthy piece of legislation? I am putting it to a speculation. As such, what has been stipulated in terms of desirable embargo with reference to conflict of interest under section 12(3) has been totally subverted by provisions included under section 12(5), which amounts to providing for by the right hand and snatching away by the left. Providence is wrong and snatching was right. This is the contradictory parable of it. Next. Resignation and removal. It has been stipulated that for the purposes of resignation by the chairperson, board presidents and members, 3 months notice will be required to the central government. It further goes to say, if mutually agreeable. Now, I mean, a legislation which defies logic. If mutually agreeable, such chairperson, president, member may be relieved from duties earlier than 3 months or allowed to continue beyond 3 months until a successor has been appointed, which is open-ended and therefore prescription for a time limit at both the ends is necessary. See, if a notice is 3 months, these are all appointed people. Notice is waivable only by payment of the requisite salary of the 3 months. Why all this? All this is to ensure insulation and protection, because bureaucrats are the best judges of knowing how their interests are to be protected by prescribing legislation, and the learned ones scratch their head when everything is drained out and everything is put on their head. Calculatedly, everything is worked up as if I have decided that I will be putting in Jitubai, and what all is necessary for Jitubai to be protected in, provide for in the law itself. This is the exercise. A personal exercise, a personalized exercise, a insulatory exercise, an exercise which is insulatory at the cost of all canons of morality. It permits central government to remove chairperson, president, member on the ground being physically or mentally incapable of performing his or her duties. You tell me there has to be a procedure. One fine morning I am not acceptable to you, you declare me physically unfit. Where do I go? You declare me mentally unfit. Where do I go? I mean, if you are wanting to be using powers, You ought to have definition as to how the powers are to be utilized. It permits further, as if physical and mental sickness was not enough, it permits central government to remove on the ground that the person has abused his position as to render his continuance prejudicial to the public interest. Every decision. But the removal can be worked out. The sword of removal can be put on your head, wild and vague, and you can be made to put your thumbs wherever they are required and wherever they are desired. It permits further central government to remove that the person has not been able to perform or has made persistent defaults. All conditions, even if you take